Hi, and welcome to Capturing the Totality of the Sexually Violent Offender. This is part of AEquitas's Foundations of Sexual Violence Prosecutions series, and I'm happy to be here with my colleague, Jenn Dolle, who I'll have introduce herself in a minute. AEquitas is really proud to be supported by the Office on Violence Against Women, part of the Department of Justice, and we're funded to provide innovative, informed, and hopefully really practical strategies to the field. We do that by resources such as this one. You'll find a lot of public-facing webinars and reports online. We participate in training events, everything from really small office-specific events to national and international conferences. We're involved in a lot of partnerships and initiatives, two of which I'll mention quickly. One is the Office for Victims of Crime Enhanced Collaborative Model Human Trafficking Task Forces. We support the prosecution piece of those task forces, which of course we'll talk about the co-occurring sexual violence that comes along with a lot of human trafficking cases. And the other initiative is the BJA-funded Sexual Assault Kit Initiative, which is focused on getting those untested rape kits tested and also trying to rethink our policies and practices so that doesn't happen again. One of the things that I think Dolle and I will agree to is that we really enjoy our role as consultant. And that means that you guys can reach out to AEquitas on a case-specific basis and ask for our advice or resources or research related to things like jury selection or identifying appropriate expert witnesses, or just being a sounding board for case strategies. Please follow us in whatever way you feel comfortable professionally. We're always pushing out new training opportunities and new resources. This series is supported by our grant from the Office on Violence Against Women, and we appreciate their support, although not everything we say today is necessarily in line with their views. And lastly, we're always trying to bring you innovative and informed practices. So where you'll see us acknowledge and credit research or others in the work that we do under our fair use doctrine. So today's conversation about capturing the full extent of the sexually violent offender is really making sure that we're broadening our view with the understanding that we have that sexually violent offenders often are serial offenders, even though their criminal histories may not necessarily reflect that. But we also know there are occurring crimes that go hand in hand with the sexual violent crimes. So we'll look at how to prosecute offenders for the full scope of their criminal activity, identifying and recognizing those crimes that co-occur, and hopefully evaluating that evidence so that we can make appropriate charging decisions and also perhaps introduce evidence of other bad acts under 404B and related motions. So before we get started, I wanted to give my colleague, Dolle, I guess her real name is Jennifer Dolle, but we have a lot of Jennifers at AEquitas, so I call her Dolle. So excuse me if I go back and forth. But Dolle, if you don't mind introducing yourself briefly.
Yeah, sure. Thank you so much for having me today. And Dolle is totally fine. It's what I've been called my whole life, so I'm perfectly fine with that. So I've been an attorney advisor with AEquitas for about 1.5 years now. And prior to that, I was a prosecutor in New York City and Manhattan at the Manhattan DA's office. And I think you and I have talked a lot about kind of we kind of had very similar paths in just different places and slightly different timing. But I handled all different crimes that, occur in New York City, but really focused in eventually on domestic violence, sexual assault, and then human trafficking. And so I helped to create our unit at the Manhattan DA's office. So happy to be here.
And I think that's why we picked you, because for this particular conversation, because the experience having handled all of those different types of crimes, I think opens our eyes to the fact about how often they co-occur, or one can kind of be viewed in the lens of another. So let's just kind of start the conversation with what types of co-occurring crimes might you be looking at when you're investigating a case, evaluating a case, or looking at charging a case that involves sexual assault or some type of sexual violence.
Yeah, and I think you hit on the head. really good point just to start off with in terms of like looking at your case out of a particular lens, right? So if you're looking at it just from this particular instance of sexual assault, you're going to miss a lot of the contextual analysis, and you might miss really that full extent of what that individual, those crimes that individual has committed. So it's really important for the strength of your case and to really kind of provide, be the best prosecutor you can, and hold people accountable and really find justice for the victim, and however that looks, by looking at a lot of these other crimes, right? And so, for instance, and a lot of these crimes that you see here on this slide really do co-occur with sexual assaults, right? And so when we think about, for instance, domestic violence, right? And so many times instances of domestic violence will include, it may come into your office as even might come into your office as something that's not a sexual assault, right? And then as you talk to somebody and you kind of get the full extent of the history of the violence and of the abuse, you see a lot of times that sexual assaults are a method of that power and control. When we talk about that power and control wheel, a lot of times sexual assaults are committed by one intimate partner against another. And it's really important to understand that does happen, so that you're really able to ask that person you're working with, that victim you're working with, about some of that, because that might not be disclosed right away either, for all the reasons that we kind of know working with victims in cases, and kind of that history of, you can't quote unquote rape your wife or things of that nature. There's still a lot of that. Strangulation is a very clear one. And so sometimes I think people think of strangulation as part of that force element of a sexual assault, right? So you're thinking, how am I proving the sexual assault? How am I proving that element that's that lack of consent, and that force? And whether lack of consent is an actual element in your jurisdiction or it's a defense, you're thinking strangulation is a really good way to prove that force and to prove that there was that injury. But it's also really important to think about charging that as a separate crime in addition to it. Human trafficking is obviously one that you and I, as founders of units, are very familiar with. And I think it's an important one to talk about, because it can really help you identify trafficking cases in your office as well. It's another benefit. So a lot of times I know I worked with victims who would come in and say that they were a victim of a sexual assault, and maybe it had happened while they were working in prostitution, and many times can also be being trafficked at that same time, right? And so really kind of trying to get, we know that sexually exploited individuals or those at risk of sexual exploitation are really many times targeted for a lot of their vulnerabilities, and are victims of sexual assaults, not only by those who are buying sex from them, but also by their traffickers. So traffickers many times will use sexual assaults as a method of force, fraud, or coercion. So I worked a number of cases where the victim had been sexually assaulted as a means of kind of putting fear and putting trauma into that victim. And then that victim was much easier to control, because in the back of their mind, they had this, that he's, when I don't do X, Y, or Z, he sexually assaults me. And that's obviously very traumatic physically and emotionally.
I think it's important that you just pointed out how some of these co-occurring crimes are likely to be the things that we see first, and some might be the things that we look at secondly. So a case may come to us as domestic violence, and once we build the trust and rapport, victims may disclose forced sex that was part of that abusive relationship. But other times cases may come to us as sexual violence cases, and then we learn through more of investigation that sexual violence is part of a greater scheme of force, fraud, and control and trafficking, or stalking, or maybe this offender has been escalating behavior, and what started as a stalking turned into a burglary that turned into a sexual assault. And part of that is also this false imprisonment. So it's really an idea of like, how can we maybe use these additional offenses as charging strategies, right? So if somebody is committing strangulation and also a sexual assault, can we charge both of those crimes or at least can we investigate them separately so that we have more evidence to move forward? And we're not just focused on a sexual assault. Oh, let's get a SANE exam, but let's also get the SANE exam for purposes of collecting evidence of the strangulation. So it's kind of, it doesn't matter how it comes to us. It's really just broadening our view of like, let's look at the broader picture. Let's look at, like you said, that context, because that context may give us really great, tools for us to use when we're charging and investigating and trying the case.
Absolutely. And that context is important down the line when we're really kind of trying to, you don't know what judge you're going to be in front of, and you don't know what crime the judge is going to be more familiar with. And really, you don't know what your jury is going to be more familiar with. And, you might have some ideas, but really, if you can come into a case and charge as many of these that fit and that you obviously have evidence for, it really gives that judge who's going to be making those decisions on, admissibility of evidence and, any number of different decisions that will affect your case. It will give them that full extent so that they really are making the most educated decisions. And same with the jury, right? They need that full context of what's happening. And I think we're going to talk about that a little bit more, but really kind of thinking about how you can expand that investigative lens is key.
Yeah. And then afterwards too. So we have here witness intimidation. We know that sexual offenses typically occur between people that know one another, whether that be from acquaintance to intimate partner. The pure stranger sexual assault is the minority of our cases. And so when even when it is a stranger, if we're not careful, we could still there could still be witness intimidation, but I think more often we see that when they're known to one another.
Absolutely. And that stalking behavior before and after, and exactly. And it really, provide you with that context, and you may miss evidence if you're not asking those questions about what was going on before and really kind of thinking that way. And I think a benefit of stalking too, which we often talk about, is a lot of stalking behavior may not be actually criminal, right? And so you can really, if you're thinking about charging that stalking as well as, your sexual assault or your, strangulation or burglary or whatever you may have in a particular case, a lot of that, those really kind of key details of like how a person has found that individual can come in without any sort of emotion or anything, and as not a crime, right? Because it's not a crime to do certain things unless it's in the context of the stalking.
Right. And our other Jennifer colleague, one of our other Jennifer colleagues, Jennifer Landheis, who runs SPARK, our Stalking Prevention Awareness Resource Center, would be very proud of you right now.
She's taught me well. I listened to I definitely listened to Jen's little, she also spells her name with 2 N's. So we have that.
But the stalking, I think we just underutilize it. We don't realize how powerful it can be. And it can be, behavior leading up to, and it can be behavior afterwards as well. And the key part of it is that it can encompass behavior that is non-criminal, but we want to talk about. And so it's a great way to bolster or supplant like motions for 404B evidence. Exactly. Because it's not separate and apart. It is part and parcel of the crime of stalking. And that gives us such a better context. So I would be in particular, because we're going to look about where can we find evidence of these types of co-occurring crimes. Whenever there's like even a micro community, I always think about looking at stalking and witness intimidation, because like if it's on a school campus or in an employment situation, you have this community of folks that are also affected by the sexual offender, and the sexual offender can be trying to get people to take sides. And so that kind of behavior where you see the offender messaging to others and sending notes and sending, private messages on Facebook, always be thinking of that stalking piece too.
Well, and that's what that image exploitation that we hadn't really discussed yet comes into play too, if you think about that, right? So if you think about someone who's, videotaping a sexual assault, but it may not, quote unquote, look exactly like a sexual assault, they can really magnify that harm in those images. And so that's something, and again, like you're saying, to kind of get someone on one side, or it's a threat of, I'm going to release these if you don't, so that comes into play a lot and is really key to think about.
Yeah, because, like modern dating often includes the sharing. I mean, I feel like in COVID, we even saw more of this because people weren't meeting in person. So there were these online flirtations, these online relationships that became quite intimate quite quickly. And, for whatever it's worth, images were being shared consensually. But then the offender who wants to use that image that they now have in their control for extortion purposes, for embarrassment, as part of a intimidation scheme, or part of just even a separate crime of, sexually motivated crime of that image exploitation. Those are all really important to look at.
Yeah, that's a really good point, that it can start as a consensual sharing, and then, possibly there's a sexual assault or non-consensual sexual behavior. And then that gets, absolutely.
Yep. Okay. So where do we find evidence of other sexually violent crimes? So now we're not talking about just separate offenses, but maybe in the sense of a serial offender or an escalating offender. What are some of those crimes, and how do we identify that? Because we know that they're underreported.
Absolutely.
So it may not just show up clearly as like on our rap sheet that we're going to get.
Yeah. So I think some of the ways you think about that, obviously criminal records, and kind of taking a look at that, right? There may be crimes that we can see that were, charged, but that, fell through for whatever reason, or so that's going to be kind of a wealth of information. But that, like you said, is really kind of the most obvious one, right? It's the one we look at first, and that we all probably look at, whether you're law enforcement or a prosecutor. That's kind of your first stop, right? So that will give you kind of a good background. But then think about too, like prior police reports, right? So really crimes that were maybe reported but never charged, that's really where you're going to get a lot of those. And depending on the police report, that might have a lot of really a wealth of information on it. And so it kind of coincides with the school reports. It's a little farther down, but think about prior police reports, not just to, law enforcement in the city, but also to campuses, right? To school safety officers. So on university campuses, you're really going to kind of get a full understanding of an individual's, especially, like we know these crimes are underreported, and many times even when reported, victims don't feel comfortable or are not able to go forward for whatever reason it may be. And so the case ends up kind of languishing and not going anywhere, but there is all this other prior evidence that's available. Civil protective orders are a really good place to look too, right? So if someone doesn't want to involve the criminal justice system, but something's happened to them and they really they have a relationship with that individual, or there's a stalking, right? We've talked about stalking as being a co-occurring crime. A lot of times, Jen's really going to be happy with me, but for, in many states and many jurisdictions, you are able to get a civil protective order for stalking. So not everywhere, but so that's kind of somewhere to think about too. Someone may reach out because they want help, but they're not ready to reach out to law enforcement, or able to reach out to law enforcement. Employee records. So thinking about, harassment in the workplace and workplace violence is, I think, on, people are much more aware of it and taking it much more seriously now. And so there are a lot of records that maybe there were, again, someone may be wanting to report that something is occurring at work, but might not have gone to the police. And other witnesses. So I think sometimes we tend to forget that, just figuring out, if something has happened at a workspace, right? So thinking about, okay, has this person, so not only are you kind of looking at records, but talking to the people that maybe that individual told. And a lot of things are kind of word of mouth, right? So as you do that investigation, someone's like, oh, so-and-so may have mentioned, or so-and-so left the job and there was something. And so there's always, ways to think about other individuals you can be talking to kind of really identify a lot of those prior sex crimes, many of which are ones we're talking about, they're not reported. So not criminal convictions, and not that way.
I think you bring up something, I've always heard it referred to as like the whisper network, right? So these are things that people just know, oh, like that's the guy that always is the last one to leave a party, or that's the guy that's always buying drinks to the youngest girls, or like there are these known things, and we heard about it kind of with like with Harvey Weinstein, how there was just this widely known, not widely publicized reputations of folks. And I think now, not all of this is obviously going to be something we can litigate and admit in court.
Absolutely.
But it's good for us to know, because we want to like kind of build out a defendant profile, an offender profile. It helps us triage our cases. It helps us build out our theme and theory of the case. Sometimes it will uncover actually chargeable or litigated prior bad acts. But I think it's just good for us to know, like, who are we dealing with? Like, who is this person? What's their MO? And it might not be, in any of these records, and it may just come from being like, hey, what's this guy's reputation, or what's this person's reputation? And then you can get some sense of like, okay, this is somebody that I want to spend a little bit extra time working this case. I want to build this case a little bit better, because while they may not have a criminal history, I can see that they've been doing what they've been doing for a while.
Absolutely. That's such a good point too, because obviously you're really kind of looking to not only the strength of your case, but also where you're going to, devote your resources. Everyone is so under-resourced, but it also, it's worth mentioning, and I don't know if now is the good time to do it, but it seems like maybe when we're talking about prior sex crimes. So I prosecuted in New York, right? And so when I started working at AEquitas, I started finding out, I think I'd forgotten about the federal rules, because we never use those. And New York has like 5 rules of evidence that are in our, blue book. But so all of what we do is case law, and we certainly were not allowed to bring prior sex crimes in as just straight up propensity evidence, but there are a lot of jurisdictions that you can, right? And so it's worth mentioning that you may be able to, we'll talk about 404B evidence, prior bad acts, I think in a minute, but with prior sex crimes, if it's a sex crimes case that you're trying, a lot of times that can come in, and there may be limitations, right? Sometimes it's only in a domestic violence case. Sometimes it's only in a child abuse case, but there are jurisdictions and the federal rules allow it. So it's worth for sure, thinking about that. But I was like floored when I realized that happened, because we were always making this propensity argument. And so anyway.
Yes, because, well, I think legislatures have acknowledged that the serial nature of offending and the underreporting of offending, in particular with sexual violence cases, you'll see the most statutes allow propensity evidence in sexually violent cases, domestic violence cases as well in some states, but to a lesser extent. And it's for any means that's relevant, which is a lot broader than look at that segue.
Exactly.
Or other crimes, wrongs, or acts, or a 404B evidence, which is the federal rule, which is mirrored in most state evidence codes, which allows these other bad acts to be admitted if for a purpose other than propensity. These are some of the ways that they can be admitted, but it is a rule of inclusion, not exclusion, which I think is important for folks to remember. So it really is for any proper purpose other than propensity. Here are some of those proper purposes. And we need to kind of make sure we always frame it as that rule of inclusion. But for sexually violent cases, there's, we've got lots of arguments to be made.
So many, and they're going to be really individualized to the facts of your case, but there is a wealth of areas that you could get prior bad acts in sexual assault cases, right? So when we're thinking about, for instance, intent, we're thinking about someone's in a domestic violence case, for instance, or in a trafficking case, what you've talked about is like those sexual assaults have an intent, right? Their intent is to control, or their intent is to exert some force or some force element. I lost my train of thought, but I was thinking about, it's like putting things back in context, right? So like in a case of an individual, like we talked about, there are, of course, stranger sexual assault cases. Those tend to be a lot, sometimes, in my experience, the easier ones to prove, right? Those are generally easier to prove at trial, and juries and judges kind of tend to understand those cases a little bit better. But then when we're talking about cases among people who know each other, which is the majority, or an intimate partner case, you really can kind of think about how, prior sexual assaults of that individual, even if they're uncharged. I mean, if they're charged is one thing, but even if they're uncharged, can kind of go to show what their motive was, right? And and then when we're thinking about, absence of mistake, that was always one that always was kind of like, mistake. Like, I've heard some ridiculous mistake defenses in sex crimes cases, right? But kind of prior, for instance, I was in a room that I thought I was in the room of X person who I have a relationship with, but it wasn't, it was this other person. Showing that person has other prior instances where they've gone into other people's rooms, right? Like if it's on a campus. So other times when they've done that to other individuals, or, that
maybe not so much the mistaken identity, which does happen. People do say that. I've heard those cases, but like, a misunderstanding of consent.
Yes, 100%. Absolutely.
I'm thinking back to the conversation I had with our colleague, John Kurland. We started this series basically talking about the perfect plan, right? So a sexual offender who's looking for vulnerable, looking for accessible, and looking for someone who they believe will not be deemed credible. Well, if you are doing that analysis, then pretty much you're also going to be uncovering evidence of motive, opportunity, intent, preparation, plan. Like that's all going to go there. So it's not even other sexual violent offenses. It could be those things about, this is a 40-year-old person who is always hanging out at the college bar. And the bartender's like, yes, this 40-year-old guy still hangs out here. He's always buying, the young girls, young boys, drinks, and then offering to take them home. Like that could be part of it.
Yeah. Or like buying drugs, right? Like evidence of someone buying drugs, evidence of, and then there's obviously kind of the motive, or, the modus operandi, kind of the one everyone always thinks of is like, is this person have such a specific way of picking their victims or committing their crimes that it goes to all of this here. But yes, I think the contextualizing, I think also thinking about how in a case where maybe you don't have that, obvious force, right? So it's a case where the force is more nuanced, and kind of bringing in the history of the relationship between those two individuals can explain why, maybe this individual was terrified and that actual physical force didn't need to happen, but there was no consent. So when we talk about kind of, counteracting that consent element.
Yeah. So those like
consent
intimidation and power dynamics and all of that comes into play.
Yeah. Yep.
Okay. So I think, we've got this case dialed in now. So how do we analyze the case once we've kind of gotten it to this point? Because I think when we talk about capturing the extent of the defendant and building out a defendant profile and looking at co-occurring crimes, ultimately what we're trying to do is make a case stronger, make it so that we can charge it, that we feel confident that we have the tools we need to successfully prosecute it. But a lot of cases, we know they fall through the system at the point of charging. And so I think we have this, okay, what are the elements of our charge? What are we looking at? What is the physical evidence that I have to support that? And that's, again, always looking contextually. We're not just looking at the assault. We're looking at evidence immediately before and immediately after, and all those little corroborating pieces to build the credibility of the victim, whose disclosure is, of course, the heartbeat of our case. What other witnesses do we have? Do we have those eye and ear witnesses? Do we have those folks that are going to help us paint this picture that we really need to paint? And then, not, forgetting that we also have and should be using expert witnesses to explain those things that maybe our jury is going to have a hard time immediately understanding.
Absolutely. And I think it's important to I think a lot of times when we think, a strict sexual assault case, we're thinking, okay, who's the person who's going to talk about the toxicology, right? Or who's the person that's going to talk about DNA? Like those are kind of some of the more obvious experts we think of, but really to kind of think about experts in some of that counterintuitive victim behavior, right? Especially if it's a relationship, I think is really important to kind of consider and can be incredibly helpful to giving your jury that context of something that just might not seem intuitive, right?
Especially when you don't have that overt force.
Mm-hmm.
A victim reports that their trauma response looked a lot more like freeze than flight. And so thinking about how our experts can educate our fact finder and also add to that contextual piece that we really want to be putting forward so that the jury is looking at this as, this almost fully formed, reality of what the victim's experience was, not this super, in a vacuum, what happened in 5 minutes, but let's look at this from a broader stance, and that can help share.
Absolutely. And for, how many cases did you see where sexual assault victims who knew their assaulter were still communicating with them afterwards, right? And for whatever reason that might be. And I think, it used to be, well, that clearly means that they weren't assaulted, but that's absolutely not the case. And there's all sorts of reasons why that happens. And so, not to take away from asking your witnesses in a very trauma-informed way to explain kind of what their thought process was, that can be really helpful at trial as well, but experts can be helpful in that type of behavior.
Yeah. And so we have a chart that we sometimes use at AEquitas where we actually have folks like write out what are the elements and then write out in that chart what evidence they have, what testimony and physical evidence, and what expert testimony they have. And I think it does a really good job of visualizing that we often have stronger cases than we think we have.
Yep.
We tend to focus on all of the negatives. And sometimes we work in offices where we haven't had a lot of success trying certain types of cases. And then we're like, oh, jury's never going to get this.
Yep.
But I think the message being that if we can develop this fuller picture, when we can use these promising practices like expert witnesses, then we're adding to our toolbox, and we shouldn't be relying on like past, lack of success to gauge like what we could do moving forward.
Absolutely. And I mean, that's part of educating juries, right? The more these cases are in front of juries, the more they're going to start to understand them. And the more the awareness grows, they're going to understand them. And I think, when you do break down your case like that, you end up seeing, like, I used to want big pieces of corroboration, right? But with sexual assault cases, a lot of times that doesn't happen, right? I mean, most of the times you don't have that particular like eyewitness that sees what happens, right? And so, but you might have the witness who sees all this behavior before. You might have the victim saying, any tiny little piece that you can corroborate, all of that adds up and is just building blocks for the jury. And so kind of going through that analysis of the charge that way is really incredibly helpful to help you see all of those little blocks you have that add up to this strong wall of evidence.
Yeah, I like how you said it. I wanted big corroboration, but it's typically
I wanted big corroboration.
One of the eyewitnesses. If it could be on a surveillance videotape,
that would be great.
We know that's not the case. Although sometimes the surveillance video can, help bolster our that could be corroboration, but it's usually not.
Well, and honestly, I think we've talked about this before, but I did have a case that was sexual assault in the New York City subway, and it was on video. And if I hadn't had it on video, I would have wondered what, it was like a trauma response 101, because the victim in this particular case just was so stoic and really never showed any emotion whatsoever. But this, it clearly happened to her. It was on video. So I kind of like to, remind people of that lesson I learned very early on. That is, just because the individual in front of you is not reacting the way that you believe maybe a victim should, or is a very different affect than what you would expect. And it's probably not going to be on video. That doesn't by any means mean that it didn't happen the way.
Yeah, that is a good lesson.
My PSA for the day.
So, and then of course, what are all the benefits to charging these co-occurring crimes? I mean, it really has so many benefits. But I have to say that there's a there's definitely a train of thought where you say, okay, I only want to charge the top charge because I don't want to give the jury too many outs to, convict on
Compromise.
something lesser. And I understand that. And I think it's a worthy consideration. I found in like my trafficking cases, my domestic violence cases, my sexual violence cases, the benefits of that, of charging the full extent, far outweighed the fear that I had in my head, because I was able to, more easily was able to talk about all of this contextual information, which I think the jury just needs. They need that, or they think we're hiding something from them.
Absolutely.
And they blame us, they blame the prosecution
Yeah.
for things that they don't know, even though, the defense maybe has motioned them out. I think that's where that's my personal take on it. So I would rather put it forward, have that indictment or that information in my case, read like the story of that relationship, the story of that crime, and then put it all forward. I think more, you're going to be able to hold the offender accountable, hopefully, if that goes well in that analysis, but it really does like paint the picture. It
Absolutely.
provides that context.
And I really do think, I'll reiterate, I think it helps judges make better decisions on, admissibility of certain evidence. If you are, having to litigate some of that for, I mean, hopefully if you're charging a lot of these co-occurring crimes, not only is your 404B, you're going to have much better arguments in all of those areas we talked about, but the judge is really going to have an understanding of what's going on to really be able to make the more informed decisions. Now you're making me cough.
I'm sorry, we're all sick of it. We all need a vacation. But
I think it's
the part that OVW doesn't agree with.
That may be their biggest flaw with what we've said. But I do think also this being able to detain someone pre-trial when appropriate and under this full extent of what actually happened is also, really invaluable when it's appropriate.
Every once in a while, sexually violent cases are a lot more difficult to proceed in an evidence-based way, without a victim's testimony, but there are certain charges that you could do that, much more likely to be able to do that, or they'll be able to withstand
a motion to dismiss. Yeah.
Exactly. And then, we don't think about this a lot, but if there are co-occurring property crimes, like those burglary crimes, that are part and parcel of a sexual assault, the restitution can be tied to those property crimes. Those can be assessed, assets can be forfeited. So lots of reasons why we want to make sure that we're putting forward the totality of the offender's criminality before the court and have the offender held accountable for that. So
just one more thing too. It really takes some of that weight off that victim's shoulders too. When you have all of these other crimes that a lot of that, as much evidence as you can get to take some of that weight off the victim's shoulders, and their testimony is really important.
I love it. And also a good plug we recently had a webinar, and I can't remember what we called it because we were purposely didn't want to say he said, she said, but we called it something else, like offender said, victim said.
Yeah, I know what you're talking about. I know what you're talking about.
But we know that that's the reality of what our jurors sometimes may be thinking of. So whatever we can do to build that case with other evidence, with that corroboration, with evidence of other crimes, with charging other crimes, it just takes some of that weight off. And I think it can be really important. Yeah. Okay, so going forward, we've got to get our law enforcement on board so that they're fully investigating additional crimes that may co-occur, that we're looking for it, and then we're litigating the admissibility, whether that be under a 404B, under a propensity, or under the fact that we're going to charge it as separate crimes. Then ultimately just trying to hold offenders accountable for the full extent and paint that picture. So thanks everyone for being with us. A bunch of additional resources. We have a ton more on our website, but some stalking, image exploitation resources, some witness intimidation, and then also a plug for our Just Exits initiative, which is our survivor-driven human trafficking initiative, where all of the survivors that work with us report this co-occurring sexual assault as part of their trafficking. So just put a extra plug in for that as well.
Absolutely.
Before we leave, AEquitas does host office hours the third Thursday of every month. That's from 2 to 4 p.m. Eastern time. You can register so you get notices about those. It's a different topic every month. Lots of range of topics, but most of them related to domestic violence, sexual violence, trafficking, stalking. It's a great opportunity to build a network of peers around the country. Opportunities to soundboard, opportunities to share resources, share promising practices or emerging trends that you're seeing. Maybe the defense is bringing up that we know if it's happening in one place, it's going to happen somewhere else in a little while.
Absolutely.
So this is me, Jane. You can always reach out. Dolle, really appreciate you being part of the conversation with me today.
Thanks for having me. And it's called Not Just a Credibility Context, Sexual Violence Prosecutions That Go Beyond Offender Said, Victim Said. For the
okay, very well done. I don't know if that's going to catch on anytime soon, but I'm a proponent of it. Let's start with that. Okay.
Yeah. Thanks, Jane.
Take care.